My apologies. We have already formed a quorum. It's the appointed time, and the meeting is now called to order. Let's invite the officials to join us.
Ooh la la. 有啲人一開咗會就嗱嗱聲叫。
They have to leave as soon as the meeting is called to order.
歡迎各方咁多位官員出席啊，包括財經事務及庫務局首席助理秘書長姚繼卓先生，就有公司註冊處首席律師何劉家錦女士，仲有就係公司註冊處高級律師薛巴加斯女士，就公司註冊處首席律師麥錦羅女士，公司註冊處高級律師鍾偉添先生，以及律政司高級助理法律草擬專員。
And Mr. Sunny Chen, Senior Assistant Law Draftsman, Department of Justice. Mr. Henry Chen, Government Counsel. Ms. Amy Chen, Senior Government Counsel. Ms. Mandy Ng, Acting Senior Government Counsel. This is the 7th meeting of the Subcommittee on the Companies Ordinance. So this is the 3rd batch of subsidiary legislation, but then for the 2nd batch earlier on, because we were held up by the council debate, and we have not been able to deal with that in time. That's why they have now been included in the 3rd batch, and therefore they will be combined. They will be combined in the 2nd and 3rd reading debate. So, would the administration please walk us through the 3rd batch of subsidiary legislation under the new Companies Ordinance? Thank you, Chairman. As the Chair just said, on this occasion, we had a total of 7 pieces of subsidiary legislation for the subcommittee to consider, out of which 4 were initially included in the 3rd batch, and then 2 were originally included in the 2nd batch, but then because of the scrutiny of the 2nd batch, because it was not extended, that's why when we scrutinized the 2nd batch, we agree with members on certain amendments, but then as those amendments had not been able to be moved in the form of a resolution, that's why we are taking the opportunity of the 3rd batch of resolution. We are trying to move them as amendment bills, and another one was about the court procedures as decided by the CFA, but then on that occasion we had to do it by way of positive vetting, and earlier on we have already moved this resolution, and the House also proposed that the subcommittee be asked to look at that piece of subsidiary legislation. That's why we have altogether 7 pieces of subsidiary legislation in this batch. Let me briefly walk through that 7 pieces of subsidiary legislation. 2 would be very simple, as I said, is an amendment to the subsidiary legislation, because as I just said, in the course of scrutinizing the 2nd batch of subsidiary legislation, initially we had already submitted the amendments to the subcommittee for consideration, and the subcommittee did not raise any objection to those amendments, and the relevant information has been contained in paper number CP bracket 1915 bracket 01. But then in terms of the text, when compared to the original proposed amendment, there were some slight changes, including the disclosure of directors' interest. Well, originally we proposed to amend section 6 of the Chinese version, but then after looking into that, we believe that with regard to Rule 7, the amendment should be made to that provision instead, because we also talk about some non-pecuniary or non-cash interest, and that's textual in nature, and therefore that should not affect the meaning of the text. That's why in the legislative brief we've already incorporated that amendment, and I understand that the Secretariat has also prepared an updated background information paper for members' reference. All right. What about the third batch of amendments with regard to the 7 pieces of subsidiary legislation? Can you brief us on the third batch of amendments? For example, the first one is about companies' unfair prejudice petitions proceedings rules. That's made in accordance with Section 7271A of the new CO. So can you explain that to us? Can you highlight the gist of the rules? Well, there are 5 included in this batch which the subcommittee will be scrutinizing for the first time. And as you said, well, it's the Chief Justice who made the company's unfair prejudice petitions proceedings rules, the CUPPPR, and there are already provisions under the new CO to deal with this, so that where there are situations whereby some members or all members have been subject to prejudicial treatment, then they can file this petition with the court, asking the court to issue an order requiring the relevant parties to take certain acts or not to take certain acts. So the system is already under the umbrella or principal legislation. But then what these rules seek to deal with is when a petition is to be filed, then the party will have to follow certain court procedures, and then the CJ has already made the rules, including the form and presentation, and also after petitioning or filing the petition, how that should be dealt with by the court, and there must be a return date to be set by the court, so that all parties will have to take the directions from the court on that day, and also at the time when the court issues the order, certain details will have to be followed. And when compared to the present arrangement, well, under the existing CO, in fact, for this types of petition, they will have to rely on the relevant winding up procedures. So there are certain rules under the winding up procedures to deal with that. And what has been changed now with regard to UPP, unfair prejudice petition in particular, where it does not have to do with the winding up of the company, we believe that there should be some independent procedures for both sides to follow. So these are the details of the specific procedures. And that would not represent any substantial change to the existing system. All right, the second one, that should come under the earlier batch. Yes, as I said, basically, we are just making some textual changes, and as I've already briefly touched on that. Well, for the third batch, for the 4 pieces of subsidiary legislation, let me briefly go over them. Well, let us deal with them one by one. The third one is also from the last batch, 2013, disclosure of information about benefits of directors, right? LN 76, right? Yes, correct, Chairman. Because in the revised report and also on the disclosure of information, let me take them both together, because in the last legislative brief we have already covered all these amendments. We have already submitted them to the subcommittee for consideration. You've already considered them, and as I said, there's a minor change that is under the disclosure of information about benefits of directors. With regard to the Chinese version, we originally proposed to amend Rule 6. Now we think that it's more appropriate to amend Rule 7, and that change has not changed the meaning at all. It's just to clarify the situation, setting out that for non-cash nature is referring to the amount. So it's been set out already. Then how about the next one? It's about LN 77, Companies Model Articles Notice. Well, Companies Model Articles Notice, well, that's to do it in the form of model articles, so that for different companies, and also the articles of association, they can also make reference to that. under Table A, and also for guaranteed limited company, there is also a Table C for them to make reference to with regard to the model articles. After considering some overseas experience, we believe that, according to different companies, and it's more convenient to set out the model articles of association, so that for public companies limited by shares, private companies limited by shares, and also companies limited by guarantee, there are 3 sets of model articles. So when companies have to prepare their articles of association, they can just make reference to these model articles. And as the old CO was already rather old, and Table A was already outdated, and therefore we just try to change the format in order to make it more user-friendly. But then I have to emphasize that despite the change, as these are just model articles at the time of association by the company, they have all the powers to determine whether or not they are going to adopt all or part of the model articles. It's up to them to decide. We are just setting out some of the model articles which might facilitate the operation of the companies, and that's for their own information, and it's not regulatory in nature.
The model articles reflect, in essence, the general practices. All right. Next, company records inspection and provision of copies regulation. Well, this is a collection of relevant regulations in relation to records to be kept by a company, and such records should be made available for inspection by members and by the general public, and also copies have to be provided to members. There are different provisions in the past to deal with different requirements in this regard, and also in relation to the time limits for providing the documents. And there are different time limits for different requirements, which is considered rather inconvenient. We have therefore come up with the regulation to put everything in relation to the record keeping and inspection. And there will also be alignment. For example, it would be 5 days instead of 10 days for some, and another time limit for other requirements. So it would be easier for a company to follow. These regulations is about the relevant documents, meeting of minutes, register of members, resolutions passed by the company, and so on. But for other documents, such as accounting record, which are subject to other regulations, they will not be covered by this regulation. So in the main, this is about records, meeting minutes, and resolutions. And such records must be properly kept and made available for inspection. All right, the 6th one. Yes, Mr. Jeffrey Lam. The provision says that you can check the records during office hours. What if it's an emergency? Is there another way you can check the records when there's an emergency? Perhaps we can have a brief introduction of all the 7 pieces of subsidiary legislation before we proceed to asking questions. Okay, so please walk us through the 6th and the 7th pieces of subsidiary legislation first. All right. It's legal notice 79, Companies Non-Hong Kong Companies Regulation. Like the Company Records Inspection and Provision of Copies Regulation, at present in the CO there are provisions regulating non-Hong Kong companies. Some of the technical requirements, for example, when a non-Hong Kong company applies for the registration, then certain requirements will have to be met. We have taken out such requirements to this regulation to facilitate future updating. This regulation basically is not different from those provisions in the current CO'd. The seventh one, Companies Fees Regulation, Legal Notice 80. Companies Fees Regulation provides that the Registrar of Companies can charge fees for service rendered or facilities provided. It's actually restating what's already in the Companies Ordinance. The fees are not changed by the regulation. As you can see in the legislative brief, the progressive fees will be extended to the limited company by guarantee for the submission of annual reports. This is to encourage compliance. So we want to extend the arrangement to companies limited by guarantee. In the existing provisions, we may refer fees as the same as another provisions provides, and now we will set out all the fees so that they can be referred to distinctly. All right. Before members ask questions, I would like to inform you that for the third batch, apart from the first one, companies, i.e. Companies Unfair, Prejudice, Petitions, Proceedings, Rules, which is subject to positive vetting. The other 6 are subject to negative vetting. So, members, please note that the difference of the 7, the first one, is for positive vetting, the others, negative vetting. Mr. Jeffrey Lam, the floor is yours. Actually, I have already put my question. I was trying to see if there's any flexibility, legal provisions notwithstanding. For example, outside office hours, if there's an emergency, how can such a request be met? I know there's nothing in the law that says that we should do something about this. As Mr. Lam says, the law provides the framework for the company to follow. The company must make available the records and documents for inspection during office hours. And we also provide a facility that if through a resolution or through its own articles, some restrictions can be imposed, but the restriction must not be too much or too extensive, so that with at least 2 hours should be allowed every working day for public for inspection. If a member wants to check a company's record, the company should endeavor to do this. We do not impose any restriction on the provision of record for inspection. If the company can meet such a request, there's no prohibition in the law. And if the member regards that there's an emergency situation, well, then the member concerned can certainly apply to the court for inspection or for access to the documents. Follow-up question? No? Other questions? All right. Members, I would like to ask you that whether you think we should invite members of the public or deputations to come to offer their views. Do we need a public hearing? Mr. Abraham Shedd. I would like to know the communication, the consultation that the administration has done with the relevant parties. And if so, what are the views that they have received, and have they taken on board the majority views, or they have been selective in accepting certain views but rejected some others? So let's hear from the administration what they've done regarding consultation. And also maybe they can tell us that they have accepted certain views, or they may have heard about some views but decided not to take them on board this time. Mr. Yu? With regard to the subsidiary legislation under the CO, we did some consultation in Q4 2012. We presented a draft legislation that we uploaded those on our website, and we also presented those to some organizations for information. But these are actually related to the detailed requirements, procedurally speaking. So we have received views concerning drafting and technical issues. When the regulations were finalized, we did take into account the views received from the public. But if you ask me whether some have not been accepted, well, maybe if it's a point about drafting and we do not agree with the party's view, then we may have proceeded without taking that on board. There was a previous suggestion, for example, that a member should give notice and that the company should inform the member of the time and place for which inspection can be done. Some companies have said this would make the arrangement difficult to implement. So we have taken this into account, and now we only talk about the principle of making documents available for inspection instead of specifying the time or the manner of dealing with such a request. I can understand the technical point of your argument, because usually if the details are difficult to implement technically, the sector would be the first to suffer. It's just like the new provision of regulating the sale of real property in the first-hand in the primary market. So if the relevant stakeholders have already submitted their views, then maybe we don't need to repeat the exercise. But of course, if it's found subsequently that certain matters were not properly dealt with, they will have to be accountable to us. All right, if the administration has already taken on board views expressed by the professionals and also by the relevant sectors, maybe we don't need to have an open hearing by us. I would like to get a confirmation that they have taken on board views that they regarded as valid, and they have to explain why they have decided not to accept certain views expressed in relation to important matters. All right. What's the feedback from the stakeholders so far? Apart from technical matters or the use of certain wording which you may not have accepted. So apart from technical issues and matters regarding to wording, can you confirm that there is no major difference in principle between what you propose and what the stakeholders have told you?
Well, yes, Chairman. When it comes to subsidiary legislation, when we come to the clause-by-clause examination, it will be a lot clearer because most of them would be consistent with the current practice under the CO, and therefore in terms of compliance, companies should not find it difficult to comply with the new rules. But then for the amendment rules, we have made the corresponding changes in light of the new CO. But then for those that might affect their operation, we have heard their views very clearly. So basically, that should not give rise to any operational difficulties. Yes, Mr. Shaka, has your concerns been allayed? Yes. That being the case, are we going to deal with B and C, that is the second and third pieces? Because we've already scrutinized them under the second batch of subsidiary legislation, but then because of the council meetings, we did not manage to complete the second and third reading debate. That's why now the second and third batch are now combined into one. So let's deal with those two first. Can the administration walk us through the changes? If there are changes, can you highlight those changes to us? Yes, thank you, Chairman. As I've just said, for the two amendment regulations, basically, when compared to what members scrutinized in the second batch, they are consistent. The only change is about companies' disclosure of information about benefits of directors regulation. In the Chinese version, originally in the second batch, we proposed to change Rule 6 of the Chinese version, but then after further consideration, we proposed to change Rule 7.2 of the Chinese version. In fact, the amendment is basically after the word consideration, and we have included the bracket phrase cash or otherwise, because we have decided that both cash and non-cash will have to be disclosed, but then after all we will be expressing that in a form of amount. That's why we have decided to include the phrase whether it's in cash or not. So this is just a drafting amendment, and that would not change the meaning at all. Sorry, I cannot follow. So which legal notice are you referring to? LN 76. Sorry, I cannot follow. I have difficulty following that. All right. I think it's an update. I think we can refer to the updated version. Can you refer to the paper number CB bracket 1 1182 stroke 12 to 13 bracket 03. Which paper? 1182 bracket 03. And it's on page 3. Can you refer to the clause of the bill? I understand that this is just a piece of subsidiary legislation, but then can you refer to the specific clause to us? Can you refer to the specific clause? Because, Chairman, I remember last time when we worked on the bill, we also touched on that, and one of those issues that we touch on was in some companies they would offer certain concession to its directors. For example, I can give some example. For example, I'm a director of a company, and when I patronize an eatery under the company, I'll be enjoying a specific discount. Do I have to disclose that? Because in the principal legislation, I was given to understand that that's not necessary because it's a non-cash benefit. But then it's a privilege over the others, even though it's a non-cash benefit. But then when compared to some staff above a certain rank, for example, senior staff, it would be on a par with some of the senior staff of the company. So it's not confined to the directors of the company. In many cases, for example, if you are working in a retail company and if you're a director, if you go to purchase or patronize that company, then you'll be able to enjoy a particular discount. So does that have to be disclosed? I think we will have to make things clear, because at the time when we scrutinized the principal legislation, apparently I was given to understand that that's not necessary. But then if you say that even if it's not in cash, i.e. whether direct or indirect, then that would mean that we might be caught by this. Well, I couldn't remember exactly where it can be found. It's clause 7. 7(2)(a). So it says whether it's in cash forms. So can you explain that to us? Thank you. In fact, 7 is not supposed to deal with what Mr. Leung was referring to, because Clause 7 is about the provision of services to the director, and in the course of that, certain consideration will have to be offered. So it's about headhunters. So, for example, if certain payment has to be made to a third party, and if a certain consideration has been accepted, then that will have to be disclosed. So here, what we're trying to do is, with regard to such payments, we have made them clear that whether it's in cash or not in cash, that will also have to be disclosed. So it's not a payment to the director. It's about services provided to the directors, and if payment has to be made to a third party. So with regard to this change, when compared to the text that we provided to members in the second batch, there is no change at all. We're just making it clear that it includes non-cash payments. Yes, you will have to look at the heading of Clause 7. Well, on the contrary, well, for clarity's sake, well, if the company offers me a card and my wife, and then will my wife be treated as a third party? Will that be caught by Clause 7? Apparently not. Please don't say apparently, because you're talking about the acceptance of certain services from a director, and as a result the company will have to make a payment to a third party. Usually we are talking about a referee. Let's say if there is an agency referring somebody to this company, so it's not about this company offering this benefit or privilege to the director and or his family. Legal advisor, can you give us some advice? Rule 7, and also the concerns raised by Mr. Andrew Leung, or is it like what the administration just told us? Chairman, I think Mr. Leung and the administration are actually talking about two entirely different things. Well, Mr. Leung's concerns apparently have nothing to do with Rule 7 that we are talking about. But then, can the administration explain to Mr. Leung as to what needs to be declared in the case that he referred to just now? Actually, Clause 7, subsection 3, actually they are also related, because under this rule, well, when it comes to third-party chairman, actually you can refer to 3A, B, C, D. Well, only those outside of 3A, B, C, D would be regarded as third party in this rule, and that can also be for Mr. Leung's information. But then for the circumstances referred to by Mr. Leung, well, under Rule 7, well, in the note for the information that will have to be disclosed, well, apparently what Mr. Leung is concerned about has nothing to do with Rule 7. So, for Mr. Leung's concern, which provision under the CO is relevant? Well, Chairman, I think we will have to refer to the second batch. It's about the regulation on disclosure of directors' information or directors' benefits. So the company is required to disclose the remuneration, the benefits, and also the loans to the directors. So the company will have to disclose all these. So it depends on whether or not this would fall under the category of remuneration. Well, for the company's remuneration to the director, even if it's related to the director, for example, the wife of the director, if the company has offered anything to the wife of the director, that would also be covered by the term remuneration. So that would also be regarded as part of the remuneration for the director. Alright, for remuneration, it's very simple. Alright, you are given a payment. But then what I'm referring to is not the remuneration. It could also be a direct liability. No, it's a concession or is a privilege. So given the fact that you go into such minute detail in the ordinance, I'd just like to clarify whether or not these would be declarable. Because you don't know, for a privilege card, you can use it or you may not use it. But then you will have to use it in conjunction with some staff. It's on a par with some staff members. It's not exclusively for you. Alright, if the company has offered a card for the director to use, the most important thing is who is going to make the payment for that credit card. No, it's a discount card. It's a privilege card. Well, I can give you an example. Let's say if it's a director and you're a director of that developer, and if that director purchases a unit from that developer and he enjoys a discount, and when compared to other walk-in client, is a lot cheaper. So does that have to be disclosed? I think I do have a doubt here. Mr. Ronnie Tong, Chairman, actually I'm not sure what you're talking about here. Well, my understanding is that this amendment in the Chinese version, well, in the English version, there is no amendment whatsoever. I was trying to make cross-reference to the English version because I don't quite understand what the Chinese text is about, and therefore I was trying to refer to the English text, probably because of my limited Chinese proficiency. Alright, if you look at the heading to Rule 7, is about providing director services to a third party, or the third party's acceptance of consideration in relation to the provision of services to directors, and under subsection 2 for the information that is provided. So does that refer only to the amount that has been received? Is that as simple as that? Well, I think the bracket says that whether or not it's in cash form. So that would also include non-cash payment. But why do we have to include the total amount? I'd very much like to refer to the English version here, because I think all we need to know is the total amount. Is that right? But then if it's not in cash form, but then if it's in other forms, then how do you assess or evaluate the value of that? Chairman, there are two levels here. For the first level, well, for different companies, they have different directors, and in this case, we are referring to all the directors and therefore we will have to come up with a total amount, and that would involve different directors. And secondly, well, as far as any individual director is concerned, if he has to make certain payment to a third party, whether it's in cash or non-cash form, under the current CO, the situation is the same. So the company will have to set out the non-cash payment, and that will also have to be translated into cash denomination, so that would be disclosed. So that's the way it is dealt with under the existing CO. But then what has been changed under the new CO is that on the one hand, they will have to disclose the non-cash payment, so they will have to disclose the total amount, and on top of that they will also have to disclose the non-cash payment and the nature of it. So that's the change under the new CO. For example, if it's a car, then you will have to spell out that it's a car and also the value of the car. But then as regards the total, that's the total with regard to the payment to all directors.
I think I understand it more by reading the English text. So the information to be provided is in respect of directors' service, the total for all directors, and you don't have to tell people how you arrive at that total amount. If it's cash, it's easy. If it's not cash, you have to translate that into cash. But you don't have to tell people how you turn that non-cash amount into cash. So the conversion process or the formula to be adopted for the conversion might be reasonable or not reasonable, or may be pertaining to some special circumstances. And if you do not tell people how you convert the non-cash payment into cash, and you just give people a total amount, it's not very meaningful, is it? Maybe even the English version is problematic. And now this Chinese text is just a translation. The issue is, how can you come up with a total amount, and people may not be able to tell what part of it is non-cash. Well, this disclosure requirement is already in the CO. In the note of the financial report, there's the requirement to convert non-cash payment into cash. And it's precisely of the problem identified by Mr. Tong, so that in the new legislation, we want to do something more. For example, 7(2)(b) reflects a new requirement, and that is for non-cash benefits. The nature has to be of such non-cash benefit must be spelled out to enable the reader to get a better understanding. But there's no need to categorize the two. That is to say, how much is in cash, how much is not in cash. You give people just a total amount, and without disclosing the conversion formula, the reader doesn't really find this useful. Should more be done? Should more information be provided? I think that's a valid point. For the non-cash amount, you don't have any standard conversion formula. You provide a total comprising both cash and no cash payments, and how much is cash, how much is non-cash, people don't know, and people have no idea whether the conversion is done in accordance with a reasonable formula. And there may be more than one items which are non-cash. So it's a big mix-up. You can't tell them apart. So the total is not really very informative. Is that the correct understanding, Mr. Top? Yes. Of course, when it comes to the disclosure, the company must ensure that on the one hand there's compliance, transparency, and on the other hand we should be mindful of the compliance cost. And this new arrangement is built upon the existing disclosure requirement, and the disclosure is to be make in the notes of the report, and actually is subject to audit. And the auditor's report would point out any problems. We believe that there is already some check and balance to ensure that it's appropriate. Do you accept it? Well, I've already expressed my worry. If the administration isn't going to do anything about it, then what I don't know what else I can do. But I don't know how many problems can be traced to such minor details. But you know, auditors don't audit everything. If it's just a minor sum, it may not be audited as such. To shareholders, minority shareholders, or the investing public, the information provided might not be fair. All right, other questions? If not, Mr. Yu, you may continue, but please note the concern expressed by the member. Apart from the textual amendment to 7, the others were already dealt with in the second batch. All right, the third one, the third piece. C, is it also carried forward from the last batch? Oh, we have covered both B and C. So let's return to A. Which document or documents? LN 75.
CB 36
CB 3600 1213. CB 3600 stroke 1213. PAS, please walk us through that document. This is Companies Unfair Prejudice Petitions Proceedings rules. As I have said, the court has to set down rules concerning the operation of the relevant proceedings. It's made by the CJ. Do I have to go over these sections? Well, in the past, it was done under the winding up rules for such petitions. But for some unfair prejudice petitions, they may not be about winding up. So we need to have a set of rules to deal with these proceedings. In the rules, it sets out the form to be used. And after receiving the petition, how should the registrar go about it, and how the return date is to be set. so that the parties, the company, the petitioner, and so on should appear before the court to take instructions, and also before the order is issued, how is it to be drafted and how is it to be published. Members, Mr. Tong? This is a new set of rules, independent of what we already have. Are there special provisions which are different from the existing companies winding up rules, and anything that we should be particularly paying attention to? Maybe Mrs. Ho? Can we have some? Any particular place that we should be paying more attention to, or any particular requirements which are different from the past? Nothing much is different procedurally speaking, but this is handled separately under the existing CO. Well, the rules are the same as those for winding up, and now in Rule 3, if the petition is not about winding up, then these rules would apply. But if the petition is related to both winding up and other matters, then first of all, the winding up rules would apply. And if there are rules which are applicable, they will be applied as long as they are not inconsistent with the winding up rules. And also in 210, it's done as like other civil cases. So if the rules are silent on anything, we can follow the relevant rules for civil cases. It's just like Cap 4A. So those rules will continue to be applied as long as they are not inconsistent with the new rules. We believe such an arrangement would make it easier for parties to comply, and will also clarify a particular point. At present, you are asked to specify the order's sort, and we also ask for grounds and also the relevant provisions invoked to support the application. And if the petition is just UPP and does not involve winding up, there's no need to advertise in the newspaper, because for winding up cases, it's a mandatory requirement unless the court orders that it can be dispensed with. And now, under the new rules, this will be up to the court to decide. All these are just procedural. Mr. Dennis Kwok. Chairman, I want to ask a question about 3.2. 3.2. If it's a petition for winding up, then we just use the existing winding up provisions or rules, and not the new rules. Is that correct? As long as the petition is or involves winding up, then the winding up provisions would apply, And also under B, these new rules, so far as not inconsistent with the winding up provisions, will also apply. Most, if not all, winding up petitions would contain some alternative applications, and most of them will be dealt with under the winding up provisions. Well, and for UPP petitions, usually there is also an alternative to ask for winding up. So the winding up provisions will continue to apply in such cases. The legal advisor wrote to the administration on the 31st of May, setting out certain proposals. What would the administration do in response to those suggestions?
Chairman, concerning the letter from the legal advisor, we have already talked to him and we have already told him about our initial response. And when it comes to the discussion of that letter, we can further explain. All right, so wait till we discuss that letter. And you then tell us what your response is with regard to the questions or queries raised by the legal advisor, Mr. Ronnie Tong. Yes, Chairman, my understanding is that, well, in most of the winding up cases, that would not involve any unfair prejudice petitions, but then in most of the UPP, that would also include a petition for winding up. And if the UPP petition is not successful, or if the court is not willing to issue that order, then one of the considerations is to ask the company to wind up. So that's the ultimate, or the last resort is the final ammunition. If the dispute or the problem cannot be resolved, then one can always apply for winding up the company. But then for UPP, the target, when compared to that under a winding up procedure, is different, because for winding up you're targeting the company, but then for UPP you're actually targeting the majority shareholder. But then when it comes to the majority shareholder, when I look at, I'm referring to the English version because I can't understand the Chinese version. Rule number 5, service of petition. At present, you only require that the petition be served on the company, but then there is no requirement for that to be served on the shareholder or the majority shareholder or the major shareholder. Is that fair? Because as I said, the nature of that would be somewhat different from that of winding up, and therefore, should there be a requirement that the petition should also be served on the shareholders? So that's my first question. Second question, of course, for the petitioner, if he sets out very clearly at the outset that the ultimate nuclear bomb is to apply for a winding up, and therefore that has little to do with the substance of this petition. But then I'm looking at my own experience. Very often at the start, we won't say that we're going to crash one another, and either I sell your shares or you sell my shares. Only when the two sides cannot come to an agreement, then the petitioner will seek the winding up of a company. So does it mean that initially, when you start with the UPP, you will just ignore the winding up procedures? Only when you seek to change the petition, then all of a sudden the winding up rules will apply. So would that smack of certainty? So are there more simple ways out so that we don't have to resort to this? Because even in the petition, even in the UP petition, if we say that, well, ultimately I might apply for the winding up procedure, but then that would not be triggered unless and until the court is satisfied that you can do that, because you will have to put up advertisements, and you also have to inform all the creditors so that they can also be invited to come in to express or to make a representation, or they can also form a creditors company and so on. So normally in UPP, before the court would rule that there should be a winding up, all these will not happen. For example, in winding up, you will also have to have a liquidator. All these will not happen until and unless the company is going into liquidation. And therefore, for the details of the winding up procedures applicable to this, well, for the time being, I can't think of any scenario that would be applicable. In fact, very rarely would this be applicable. So why do we have to make things so complicated? Why do we have to look at whether the petitioner has alternative requirements, and then we will have to look at the winding up rules to see which rules would apply? For example, if he just includes this as a statement, ultimately he might seek a winding up. Does that mean that they will have to put up an advertisement? Because under the winding up rules, they will have to put up an advertisement to that effect. So I just think that is unnecessarily cumbersome. PA Principal Assistant Secretary, can you explain that? My understanding is that that's the proposal by the CFA or by the Chief Justice. Theoretically, this might occur, but then in practice, if it doesn't have to do with winding up, why would somebody institute this unfair prejudice petition? Only very rarely would that be done. And if both sides are not able to come up with an amicable solution, for example, if a director or if a shareholder seeks this unfair prejudice petition, is already put on the table. Both sides are not happy with the situation. So can the DFJ give us some figures? For example, during the past 5-10 years, how many such UPP have been filed, and in the end, how many ended up with a winding up? Well, my suggestion is that the number would be very small. Either the judge would decide on a figure. Well, either side will bid for that with the permission of the judge. If you two cannot agree on the value of it, then I'll get a third party to set a figure, and then both sides or either side will bid for that. Well, please note that this paper was initiated by the CJ from the CFA. It's not initiated by the DFJ or the Bureau. Well, we can only put this to the administration. We cannot put this to the judiciary. There is no way that we can invite the judge to come and answer our questions, right? I understand the difficulty of the administration, but then the only thing that I can do is to put the question to the administration. Deputy or PAS, I'll say something and then I'll see if Mrs. Ho has anything to add. Well, according to my understanding, well, for UPP, very often that will end up in an alternative application for winding up. So in reality, if that should happen, if under an UPP, if there is also an application for winding up, I think the difference is very little, because basically you will also have to refer to the winding up rules and also the relevant arrangements under those rules, because all the arrangements will have to be done under Cap 32. So in overwhelming majority of the cases, there is no difference at all from the existing practice. But then specifically, we have come up with this set of rules to deal with UPP, unfair prejudice petition. Yes, that might only constitute a very small number of cases, but then we cannot rule that out altogether, because the winding up rules themselves are very lengthy. It involves a lot of liquidation or winding up procedures. But then if it only involves UPP, then there is no need for us to refer to those detailed rules. And then they will also have to look at the winding up rules to see which rules would be applicable, and that might not be very clear. That's probably the reason why we would just be looking at this very simple UPP, and we have now come up with this set of rules to deal with that very narrow scope of situation. And there are only 9 rules As you can see, probably that's because of the nature of these petitions. They are very, very simple in nature. That's why we only have very limited rules that would be applicable. So we believe that that would also be useful because the situation would be a lot simpler. I think the response from the sector would be that, all right, if there is an alternative relief for winding up, then you will have to put up an advertisement. Then the sector's response will be that I'll never incorporate that, so I'll wait till the last moment. Well, it might not be necessary for them to put up an advertisement. That's precisely my point, Chairman, says Mr. Ronnie Tong. All right, according to what I heard just now, if you have an alternative requirement for winding up, then you will have to put up an advertisement because winding up rules would apply. But then the sector's response would be that, all right, if that is the case, because I don't want to put up an advertisement, then I would not include that in the petition, because putting up an advertisement would affect the reputation of the company, and therefore many people would not want to disclose that. And if that's the case, then the sector will think that, all right, I'll not include that statement, and then if it does not work out, then I'll then apply for winding up. That might be the response from the sector. But then my view is that one of the ways out is that why don't you just restrict this to UPP proceedings, and then for all the others, they will all come under the winding up rules, and that would make it clearer and easier to understand, or else you will have to check which rules will apply, and then you will have to make a choice. Honestly, it's not very user-friendly because it's not that easy to understand. But then can the administration also respond to my question, that is in terms of service of this petition? You should also require the petitions to be served on the shareholders. I think that would also be important. Can you explain? In particular, 5.1 on the service of petition. Can you explain that a bit further? I'll defer it to Mrs. Ho. Yes, under 5.4, we have already made it clear that for a petition, that would also have to be served on every respondent named in the petition. So that's the question raised by Mr. Tong. So the petition will have to be served on every respondent named in the petition. In other words, we will have to name names in the petition, right? Yes. All the respondents will have to be served with that petition. As regards the second question, well, for application for winding up, the consequence could be dire, because if there is a petition and if there is an order for winding up, then the date will count from the day on which the petition is filed. And, well, whatever happens after that date might no longer be effective unless you've got the approval from the court for that to proceed. For example, for any monies that is paid or received. So under 32H, there are already requirements for advertisements to be put up, and you will also have to serve it on the registrar or the company registrar. And if you've never thought about applying for winding up, you should not include that in the petition, because once you've got the winding up order, the consequence could be very dire, and whatever happens in the interim could all be invalidated. And therefore, you have to think it hard. You will have to think it through very carefully. If it's just about UPP, then this rule will apply. But then, if there is a possibility that a winding up order could be issued because of the dire consequence, the winding up rules will also come in, and that's the current arrangement too. Mr. Tong, Mr. Kwok. In other words, overwhelming majority of the petitions will be subject to two sets of rules in the future, right? Because the most complicated one is Rule 3 2AB. Well, for the existing winding up rules, they will apply. And also, for this set of rules, they will also apply unless is disproportionate. So, both sets of rules will apply to most of the petitions. That would make things really very complicated. Is that right, Mrs. Ho? Would that be very complicated? Well, under the Companies Ordinance, the situations have been segregated because in the relevant amendments, 32H have been amended. So 32H will apply to winding up situations. We believe that for purely winding up cases, we'll refer to Cap 32, Subsidiary Legislation H. But then for UPP, as the set of rules are made under the new CO, and therefore in the principal legislation, it's already made very clear that the CJ can make those rules. And in accordance with that new arrangement, we have now come up with this new set of rules.
And these new rules are clear. If the petition is about UPP only, then these new rules apply. What if the petition covers both UPP and winding up? Can we have one set of rules for such a combined petition instead of applying two sets of rules on one single petition? As I've said, under 32H, it applies to 168A, access winding up, unless there's a contrary provision somewhere. So people have to look carefully whether it's related to 168A, and certain winding up provisions may not be applicable. But so with the new rules, if a petition is about UPP, then it's clear, cut and straightforward. The new rules apply. There's also the legislative intent under the new CO, and that is why we give CJ the power to make rules to regulate UPP proceedings. Mr. Ronnie Tong, I think according to case law, local and UK, it has come under criticism that we should not lump together winding up the provisions in 168A proceedings. That's why we need a new CO. How are we going to deal with such subsidiary legislation? Can we just say yes or no? Or can we propose amendments? Can we offer comments? Well, these rules are made by the CJ. Maybe there should be one more rule that if it's purely on 168A and then failing to reach an agreement, there's an amendment or amendment is sought. Perhaps the shareholders can no longer work together, so they may want to go separate ways, and then there's an application to change the petition to that of a winding up petition. Would only by then that the winding up provisions be applicable? Or should that be a fresh petition required instead of trying to morph a 168A petition into a winding up petition so as to avoid misunderstanding? Can we make some rule concerning these matters? I'm just offering some views. Rather technical matters are at stake. Well, PAS, well, I don't know if we understand Mr. Ron's views correctly. Actually, what we're trying to achieve is exactly what Mr. Ronnie Tong is suggesting. If it's just a UPP petition, then all you need to do is to look at these new rules. But if subsequently you put in an application to change, to amend the petition, then the new petition, which is about winding up, would be subject to winding up provisions. But where can I find such a distinction? My understanding is that when you file the application, if it's purely on 168A, these rules apply. But if in the first petition you mention an alternative winding up request, then both sets of rules will apply. Where can I find the provision? It's in Rule 3. But if there's a subsequent amendment, or would you make it explicit that the winding up provisions will only apply after the amendment is effected? Well, under Rule 3, we talk about the time the petition is filed, whether that petition includes an alternative application of winding up. If so, then under Rule 3.2, then the winding up provisions and these rules will both apply. But of course, we'll look at the winding up provisions in the May, because these rules would only apply so far as they are not inconsistent with the winding up provisions. But of course, if the petition doesn't include any alternative application, it's just purely UPP, then these rules apply. But of course, if there's a subsequent petition on winding up, then winding up rules apply. And if the first petition is on UPP and then you wanted to tack something onto that provision regarding winding up, well, then depending on the subject matter, the relevant rules would apply. Well, perhaps you can give us a paper setting up the scenarios and the applicable rules. I think Mr. Tong is trying to seek clarity. Well, maybe we know what would apply, but perhaps the PAS can liaise with the judiciary and also our request to have one more provision setting up the applicable rules if there's a change or an amendment subsequent to the filing of the first petition. I don't think we are in disagreement in any way. We just want to seek clarity. Perhaps you can talk to the judiciary whether we can have some clarification. I don't think we are objecting to anything, actually. I think we'll see if we can do something about Rule 3 application. It's not really a difference or a substantive difference. It's just a question of how we can best express our intention. Okay, we can move on. Can we do the cross by cross?
係，都係600-12-13。
One, this one, Chinese version. Perhaps we can use the Chinese version. It's a 600 stroke 12-13. The first one is the commencement. This is the same as the section 727. And then second interpretation, we'll return to this when there's some amendments, and then 3 application. If the petition has got nothing to do with winding up, then it is apply. And also, the petition must be in the form set out in the schedule, but the necessary modification can be made if required. It's under 3(1)(b). 3(2). If the UPP petition includes an alternative application for winding up, then under 2A, bracket 2, bracket A, the winding up provisions apply with necessary modifications that the circumstances may require. And under bracket B, these rules, if not inconsistent with the winding up provisions, will also apply to the petition. And also the petition must be in the form set out in Form 2 in the appendix to the company's winding up rules, or CAP 32H. And bracket 3 is that if the alternative application is not proceeded with, although it's in the original petition, then the winding up provisions cease to apply, then these rules continue to apply. Rule 3, bracket 4. Well, this is for clarification. That is to say, the cessation of the application of the winding up provisions does not affect their previous application to the petition, and anything that has been done before this application of the winding up provisions will not be affected. 5. These are simple rules. Therefore, in 5, we specify the rules and practice of the High Court for regulating others' civil procedures would apply if they are not inconsistent with these rules. Legal advisor. As Mr. Dennis Kwok has said, I have written to the administration seeking some clarifications. One of the points made is about 3 bracket 2C. If the UPP petition includes an alternative application for winding up, then bracket 2 talk about which rules or provisions will apply. And under bracket 2, bracket C, the petition must be in the form set out in Form 2 in the appendix to CAP 32H. And in that form, you can see that there are certain rules, certain provisions concerning winding up and related matters. For example, if the court is to issue an order, that order may take the form of a winding up order, but there's no box for you to fill in the grounds to seek a UPP relief and so on and so forth. So, is it that although the petition applicant has to use this form, necessary modification can be made so that he can put the grounds to support an UPP petition into that same form, PAS. Actually, under 3 bracket 2 bracket A, we already said that the winding up provision with any necessary modification that circumstances may require apply to that petition. And also in the winding up rules, 22 states that the form in Form 2 in 32H can be modified. So modifications are already required. So although we specify that Form 2 must be used, but the applicant can still make necessary modification to the form in order to set out the grounds for seeking UPP relief. But if you read the wording that the petition must be in the form set out in Form 2 in the appendix to the company's winding up rules, it mentioned nothing about modifications. Of course, under the winding up rules, there are other rules allowing the modifications. So perhaps we can look at 3.1b. If the petition does not include an order to wind up the company, then B says that the petition must be in the form set out in the schedule, and also with any necessary modification that the circumstances may require. So modifications can be made, and that's an explicit provision. Perhaps under 2C, we can also have something explicit to allow modifications. PAS, what do you say? If you think this is appropriate, can you take it on board? 3.2a says out that the petition includes an alternative application.
Then the rules would come into play, and then under 22, it says that the form can have some flexibility, and under C is a bit cumbersome. That's why we believe that that's not necessary. But if members express a concern, we can also look into it. Yes, please. If there is a need, then you can change it.
局方可以吸納佢嘅意見，好嘛？好啦，我哋繼續啦。
Let's continue. It should be 4, right? Yes. 4 is about how it should be presented. It will have to specify the grounds on which it is presented and the terms of any order that it's sought by the petitioner, and then it's for the court to set a return date. What's so special about this return date? That's for the petitioner and also the respondent and also the company. So they will have to attend before the registrar or a judge of the court for directions to be given in relation to the procedure on the petition. Because when all the litigants are there, the registrar or the judge of the court will explain how the proceedings would proceed. So that's under 4.2. And then on fixing the return date, it also says that the court would also have to return to the petitioner sealed copies of the petition for service. All right, any questions? If not, then 5. Yes, legal advisor. Yes, thank you, Chairman. On 4.2, actually, I've already written to the administration seeking some clarifications, because if you look at 4.2, it's about the hearing, whether it's going to be heard in chambers or in open court. Because if you look at the existing relevant practice direction relating to bankruptcy under 5.6.3, actually concerning bankruptcy and winding up proceedings, the hearing will be held in chambers. So can the administration clarify with regard to the UPP and also the related procedures? Does that mean that the court would be issuing practice directions directing that such hearings will be held in chamber or in open court? Because unless it's otherwise stated, the relevant proceedings would be held in chambers. So if there is a practice directions that's setting that out, then usually most hearings would be held in open court. So can you provide further information on this to members? PAS? Yes, Chairman, as the legal advisor just said, under the current Rule 4.2, there is no specification as to how the direction should be issued and whether it has to be held in chambers or in open court. Without further specification, then it's up to the judiciary to decide. And if that's the case, then we believe that the judiciary, if it feels necessary, then it would be issuing practice direction. setting out the relevant requirement. And therefore, in the rule here, there is no need for us to specify. We can leave it to the court. Well, for winding up order, does it say that it will have to be held in chambers? Or would that be left out to the court or the judge who will make a decision? All right, under the existing bankruptcy or winding up proceedings, there is a relevant practice direction issued by the court, as I said. With regard to proceedings relating to bankruptcy and winding up proceedings, similar to that under Rule 4.2, well, that's now done in chambers. So that's in accordance with the practice direction. If that's the case, and if they rely on practice direction for proceedings relating to bankruptcy and winding up proceedings, then there is no way that we can spell that out in the regulation, stipulating that it has to be held in chambers or in open court. I think we will have to leave that to the court. Yes, there is another point that I can supplement. In fact, on winding up proceedings, well, under the existing rules, Rule 5 and 6, actually it sets out that which types of hearings or which type of proceedings would be held in chambers and in open court. So in the rules or regulations, there are already specifications as to what type of hearings will be held in chambers, what in open court. With regard to the proceedings under Rule 4.2, the practice direction has also said that such hearings will also be held in chambers, and therefore both the administration and members can consider this. With regard to the hearings under 4.2, if they would be held in chambers, then under the existing rules or regulations, they can also be set out very clearly. Yes? PAS, have you heard the advice by the legal advisor? You can make a comparison, or you can also seek the advice from the DFJ or the Judiciary to find out what they're going to do. So, do we leave that to the Judiciary, which will then come up with a practice direction, or do we deal with that under our own regulation? Well, as I said, the rule is to be made by the CJ, because this proceeding will not be set out in the regulation, and also for the practice direction, that will also be issued by the Judiciary to the relevant parties for their consideration. And that's why on this particular point, after all, it's a procedural matter. We believe that we can leave it to the Judiciary. All right, let's continue. Thank you. Rule 5 is about the service of petition. The petitioner must upon receipt of a sealed copy of the petition, then at least 14 days before the return date, serve a sealed copy of the petition or the service copy on the company at the registered office of the company, and also every respondent named in the petition. So 1 to 3 under Rule 5 talks about the actual way of servicing the petition. All right, for the office, the service copy will have to be left at the registered office of the company, and if there is a company or it has to be left to or with the officer or employee of the company found there, and so on and so forth. All right, any questions? If not, then Rule 6. Rule 6 says that on the return day, and if necessary, after the return day, with regard to the various stipulations under Rule 6, the court may make certain directions. For example, the court might believe that certain party will have to be made aware of that, and therefore it can direct that the petition be served on any person, whether in connection with time, and so on and so forth. And also with regard to the statement of claim, defense, and reply, whether they have to be delivered, and also whether or not the petition has to be advertised. So the court will look at the circumstances and decide whether or not it has to be done. And the court can also decide on the manner in which any evidence is to be adduced at any hearing before the judge, whether or not there would be cross-examination of a person and so on, and also the manners to be dealt with in evidence. And it can also appoint that the various parties should go through mediation, and only if mediation fails, then the court will deal with the case. So the court can also make this sort of direction. All right, Rule 7, drawing up of order. Is for the court to deal with the petition, and then when the court has to draw up the order, then the petitioner or the petitioner's solicitor and all other persons who have appeared at the hearing of the petition must submit a draft of the order to the registrar, who will then decide on how the order should be made, and the registrar may also make an appointment to settle the order. No question. Then Rule 8, upon the issue of the order, then how it should be dealt with. Unless the court otherwise directs, the petitioner must serve an office copy of the order on the company and also on the registrar of companies. Subsection or subparagraph 2 also talks about the service of the order. For example, it should be sent by post to the register office of the company, or at its principal or last known principal place of business in Hong Kong. And subparagraph 3 refers to special circumstances. For example, if it involves reduction in the share capital, or if the article of association is changed, then under the new CO, there are already detailed arrangements relating to these. For example, there are certain acts that have to be committed, or else that would also have to be dealt with by the company's registry, or else for other circumstances they will be dealt with under this. So it's proposed that the relevant provisions or the relevant procedures would be left to the CR or the relevant company. Well, in my letter on Rule 8.1, I've already raised a question. Well, we note that under Rule 8.1, it provides that the petitioner must serve an office copy of the order on the company and on the registrar of companies. But then there is no deadline for this. So can you clarify? Is it that there is no requirement for the document to be served on the company and the CR by a certain date? And if there is no such deadline, and if the petitioner fails to comply with Rule 8.1 in servicing the order to the company and the registrar of companies, what will the consequence be? And if there is no consequence, then actually whether he does it or not, will that have any consequence at all? Well, the fact that there is no deadline, the general understanding is that he will have to do so within reasonable time. And the consequence is that, well, it's like all other rules made by the court. Well, that might be somewhat different from other regulatory rules, because for the rules made by the court, very rarely would it attract criminal sanctions. So when the court makes this rule, that's for the relevant parties to follow. But then if there is a failure to comply, then it's like all other orders made by the court that would be dealt with administratively. For example, if there is something that has to be submitted to the CR, and somebody might seek to the court that this be served on the CR, but then the actual arrangement will be that if there is a court order involving the company, and the company will have to take certain action, and then the petitioner will have an incentive to serve the order on the company. Because if he fails to do that, then there is a chance that the court order might not be executed. And therefore, in serving the order on the company, the petitioner has already got sufficient incentive to do that, but then for serving the order on the CR, well, if he fails to do that, then that would be dealt with administratively. Well, there are two further points, Chairman. Mr. Yu, can you also clarify on point 1, what do you mean by administrative means? And secondly, coming back to 8.1, why is there a need for the petitioner to serve it on the CR? Because whether the registrar receives it, what's the difference? So we have to know the reason why you have to do it. If there is a purpose to be served by serving the order on the registrar, and if any failure might mean that other parties might be affected, then should it be more appropriate for you to set a deadline so that the petitioner will be required to serve that on the registrar?
What will be the consequence if the petitioner doesn't do it? And he filed and petitioned, and then he just leave it at that and do nothing else to serve the order. Well, there's no need to worry, because if the order is to be executed or enforced, he has every incentive to serve the court order on the relevant parties. As for the service on the registrar of companies, well, this is in line with winding up proceedings. The registrar, upon receipt of the order, would enter that particular order in the register. This is good for corporate transparency, because if it's in the registry, then public inspection is possible. But we don't need to impose criminal sanction for failure to do this. Of course, if it has to do with a reduction of capital or an alteration of the company's articles, then other people might be affected by the change. So there are other provisions imposing criminal sanctions on those who fail to do this. But if no one else is going to be adversely affected, then we don't think there's a case for criminal sanction. We can deal with such failures through other means. If someone feels that he's prejudiced by the failure to serve, then he can apply to the court, and the court can issue a supplementary order directing that the petitioner serve the order on the registrar of companies. Mr. Yu Si Wing, question about service of order. Or Mr. Martin Liao, I want a question about the relationship between the order taking effect and the service of order. According to High Court rules, if you want to enforce an order, a court order, then you must serve the order on the parties who have to do something. It's in Cap 4A. If you want to enforce a court order, then service must be done first. If you don't serve this on that party, then there's no way you can enforce that order. Follow up? So there's a relationship between service and enforcement. Yes, service comes before enforcement. Therefore, the one who has the order has an interest in this. He will make sure that the order is served. Yes, otherwise enforcement cannot be done. Further questions? Okay. We're now on Rule 9, advertisement of order. Thank you, Chairman. This is a simple rule. If the court of first instance things fit, it can require the order to be advertised in such manner and time as it directs. Questions? If not, then we move on to the schedule. So it's related to Rule 3, Rule 3 bracket 2C. 3.2c. This is 3.1b. The form specified in the Rule 3.1b. That is, the petition is on UPP only. This is modeled on 32H of CO with necessary modifications. The information to be filled in is something professionals are very knowledgeable about, the names, addresses of petitioners, full company name, and so on and so forth. And we also set out the different circumstances provided for in the new CO, and they will have to indicate which sets of circumstances apply. And under G, the terms of the order sought, and also H, the respondents have to be named. But these are just basic required informations, but there can be modifications. Yes, under 3.1b, if the circumstances are complicated or different respondents are involved in different ways, then the necessary modifications can be made. But these are basic items required, but modifications are possible to suit the special circumstances. All right, so we have completed A, B, and C. We would proceed to D in the next meeting. Members, I would like to talk to you about our meeting arrangements. We'll continue with D next time. Oh, I was late, so have we talked about the one on inspection of records? Well, it's B and C, which were already scrutinized under the second batch because of filibuster. The amendments could not be moved. Oh, you were talking about E? Inspection and provision of copies. Oh, we haven't done that. It's D. Next time we are going to start with D. And yours is E, the fifth one. So we haven't done that. Meeting arrangements. On the 12th of June, let's refer to the timetable. We have to arrange our meetings in accordance with our schedule. The expiry of the period of scrutiny is the 26th of June. It can be extended to the 17th of July. If there's no need to extend that period, we'll have to report back to the House Committee on the 14th of June. Well, it's a bit of a rush, so I expect that we need to seek an extension. And the period will be extended to the 17th of July. In that case, I will have to make a report to the House Committee on the 5th of July. And if amendments are proposed, the deadline for giving notice is the 10th of July. So the extended deadline is 17th of July. That's the last day of this current term. 17th of July, the very last day of the current term. Regarding A, the UPP rules is special, is subject to positive vetting. And B, from B to the last one, the 6 others, they are different. They're subject to negative vetting. So, are we going to proceed to, well, as one batch on the 17th of July? Well, because otherwise there's no time. So our timetable is rather tight. If we can complete ahead of the deadline, we don't need to convene too many meetings. I think we should meet on the 11th of June, Tuesday, from 10:45 to 12:45. That's the next meeting. The third one, the one after next, will be held on the 20th of June from 2:30 p.m. to 6:30 p.m., 2 sessions for 4 hours. And then the 24th of June, Monday, 10:45 a.m. to 12:45 p.m. And then the next one, the 25th of June, Tuesday, 2:30 p.m. to 6:30 p.m., another 4-hour session. Do we need that many sessions? Well, the Secretary has make a lot of provision. We may not be able to make it on the 20th of June because there's a council meeting on the 19th of June, and if overruns to the 20th of June, then we may not have the meeting on the 20th. So on the next at the next meeting, the 11th of June, we'd like to make some estimation. Let's hope we can complete the scrutiny by the 24th of June. Let's see how we go. Because we have already taken out the one on search, on company search, things are now less complicated. All right, today's meeting is adjourned. Thank you.